Morning, everybody. I'm Chris Tagg. I'm a board director at PASA, and I've the pleasure of hosting today's webinar. The topic is GMP Equalisation and Administration, and we also have the launch of anti-franking guidance. The recently established GMP Administration subgroup discuss what they are working on at the moment and take your questions and suggestions for future areas of focus. Join us for the first look at the new guidance from the anti-franking subgroup, which launches today. The panel includes Stephen Blakesley, Mercer and Administration Subgroup Chair, plus Felicity Boyce, Aon and Anti-Franking Subgroup Chair, and Claire van Rees, Sackers, an Anti-Franking Subgroup Member. So I'll now hand you over to Stephen.
Good morning, everybody. So yeah, as Chris said, I'm part of the PASA GMPE Administration Subgroup, and I'm going to talk a little bit today about why we're here and what we're trying to do. Now, on my first slide, that is the USS Missouri. Some of you may know that was the last battleship that was ever commissioned by the US Navy, and it was also the site of the ceremony that marked the end of World War II. It was also the ship that Cher was sitting on when she was pondering what she would do if she could turn back time. Now, I don't know what Cher was thinking, but I'm pretty sure she wasn't thinking I'd account for the impact that gender differences within GMP have on member pensions. But if that's what she was thinking, then back in October 2018, the High Court granted her wish. That's when we had the Lloyd's judgment passed down, and that's when we got to see what Cher could do if she could turn back time. Now, if we move on to the next slide, we'll see that much of the discussion about GMP projects to date have been around the history. It's about looking at the project, how you're going to fix those problems of the past. And I really recommend the other PASA sessions that are going on this week, or the YouTube videos of the ones that happened so far, and they give you really useful information about you planning for those projects and the different things that you need to do. But one day, those projects will be over. I appreciate that if you're in the middle of your GMPE project, it might not feel like that right now, but it will come to an end. And at the point that project comes to an end, you've got to start thinking about life after GMP. And that raised a question for us in an administration group at PASA about, well, do you believe in life after GMPE, or does it just feel too far away? Well, here at PASA we do, and that's why we've got an administration subgroup now. Schemes and trustees and decision makers are moving from some of the high-level principle decisions, for example, am I going to convert or am I going to go dual records, and are moving into some of the detail about how actually going to implement their GMP equalisation solutions. And this detail is going to affect the ongoing running of a pension scheme. And if you're affecting the ongoing running of a pension scheme, you need to make sure you've got your administrators involved. So we've got a group together, and that group includes in-house pension administrators, people from third-party administration firms, and other trustee advisors. And we set this group up with a specific purpose. And that purpose is to help administrators, and to some extent help anyone in the pensions industry, identify the issues that GMP is going to give you in running your pension schemes on an ongoing basis, and then provide help or support and guidance how we can mitigate some of those impacts. Now, on the next slide, we've got a list of the firms involved. I think a key point that I want to make here is this is not a closed shop. So if you're sitting there and thinking, wow, this sounds like the kind of stuff I'd like to get involved in, like to be involved in trying to think about how we can solve some of the issues there or put forward new issues for us to consider, then please, we can have more people joining that group. And within our group, there are 3 things that we've focused on. Number 1 is thinking about what our key points are. What are the key things that drive what we're thinking about? Number 2 is what's the role of administration? What's the role of your administration experts in your GMP equalisation solution? And then the third part is the Q&A document. That's going to be a living document. It's going to grow as we get more questions and come up with more answers. And the initial version of that is coming out in October 21. So if you move on first into what are the key points for life after GMPE? Well, number 1, our key point is whatever you're doing, please engage your administrator as early as you can in your GMP equalisation work. There's a number of key questions that your administrator can help you with. Some of them are fundamental. For example, if you're going down a dual record solution, can your administrator cope with that? Have they got the capability to be able to do that? And if it's not ready yet, when will it be ready? But there's also some more nuance around that. So, for example, different solutions to dual records might work in different ways, and maybe the project can help that. It can make sure that the data you produce is produced in a format that your administrator can readily use, and not something that's going to make stuff even more complicated. When you look at maybe conversion solutions, there's something administration can help with in terms of this benefit structure, which you're looking at post-conversion. How does that interact with how we administer the scheme? How does that interact? How's that benefit structure? How's that going to change the way you want to run the scheme? And then you get into some of the detail. I've seen, for example, some things around conversion structures and contingent spouses pensions. It's really important when you get to some of those complexities that you're coming up with solutions that you talk to your administrator about, so you can say, well, how does this affect you guys? Secondly, when looking at the implementation of your GMPE solution, a lot of that can be about finishing the work with a project, about data, that's critically important, about member engagement, that's also key. But it's also about dovetailing in that operational readiness for your administrator, so that at the point you bring in the new data and you talk to the members, you've also brought in line the new capability that you need to run that solution. Then we get on to the sort of the Q&A part of what I was talking about. We need help from everyone out there to identify what are the complex issues, what are the key operational bits that are causing administrators concern or causing trustees concern. And we want to find compatible solutions. And what we mean by compatible is that different administration works in different ways, different administrators work in different ways. You can't necessarily have one solution that's going to be right for everybody, but you can look to try and make those solutions compatible so that they could transition between different administrators. Different administrators can look at a concept and see how to apply it to what they do. And the fourth one, we've got a kind of goals. Where can we get a commonality of views? It's really important within our group that we've got different perspectives, different opinions on different experiences about GMPE and about administration. And we have this aim that maybe out there we can find some sort of default approaches which will make things straightforward. And then when we think about the second point, so the role of administration, so we do need to step back into the project. And we try and think about the administrator's role in GMPE in these three key phases. So the project, I'm not going to spend loads of time about this because we're really focused on life after GMPE. But I've already talked about how it's really important that think about the data and how the data coming out of that project can be used by your administrator, about the solution of design, making sure your administrator is involved in that. But also there's membership insight. All pension schemes have different cultures. The trustees will have some insight into that, but your administrator talks to those members every day and they'll have some insight into how the culture of the pension scheme can help you design the right communications, make sure you're engaging with the members in a way that takes that into account. I've already mentioned implementation. Again, you can see it's about data and about member support being key. But as I mentioned earlier, it's about bringing online the operational capability that you're looking to bring in at the same time you're implementing your GMPE solution. And then that's when we get onto life after GMPE. Now, you'll see in every box we've got data, data, data. Don't need to tell you guys how important data is, how it's the cornerstone of making sure that you can run the pension scheme. And that's why it's so important that you're thinking about the administrator and getting the administrator's view on data throughout the life of the project. You've got the data coming in at the beginning. Implementation, need to think about, is that data fundamentally in a way, designed in a way and coming out in a way that fits into the administration platform, fits into the administration ways of working? And is it in a format that your administrator can cope with, that they can move into their administration platforms without having to like loads of manual revisions to? But life after GMPE isn't just about data. It's also about the ways of working. It's about making sure your administrator has got the training involved, has their people had training on the fundamentals of GMPE equalisation and understanding how it affects the scheme. Have the process and controls been updated? And have you thought through some of those details, some of those more detailed decisions that I mentioned, have you thought them through and thought them into how they're going to affect the administration going forward? And then a key part, I think a key output, we've already talked a little bit about the principles that we've got and trying to promote getting the administrator involved in exercises early. But another key output, and maybe the most important one on an ongoing basis from the administration subgroup, is our Q&A document. Now, I mentioned before that we see this as a living document. We're looking to get the first one out in October, but we want to make sure this grows over time and that we can add questions to it, we can consider those questions, and we can add answers to it, and we can make sure that they're available to you on the PASA website so you can go and get them. Now, I've got examples here of the questions that we've been looking at, which you're going to see in the first version of that Q&A that comes out in October. Now, the first one of those was getting into the detail. We're looking at dual record solutions. So your Bs, your C1s, your C2s. And looking about what you do when members in payment and you're doing your checks to see if the member is advantaged or disadvantaged by their gender. And we're doing checks to see if that position is changing over time. And is it changing from them being disadvantaged on their gender and advantage on the opposite gender, or vice versa? And the question we had as a group was, how often do you need to do that check? Do you need to do that check every time you make a pension payment to somebody? Or is it okay to do that check just at the points in time when the pension might change, maybe when pension increases occur, or maybe when a member cross either age 60 or 65 and some element of that GMP is coming into payment? The reason we got asked that question is that when you look at option B, you get scenarios where you'll spot some of those crossovers from advantaged to disadvantaged in retrospect. So you get positions where you'll spot those retrospectively, and that might mean there's a small arrears payment to members. We wanted to work through whether we thought that was a reasonable compromise. Now, when we issue the answer, we'll have more detail. But as a headline, we thought both of those methods were okay. When we balanced up how different administration platforms will work for different administrators, and we balanced up the risks involved with the data that we're now handling, and what was an appropriate way to mitigate that. And we also looked at the amounts that tend to be involved for people and how often these events occur. We landed in a place that said, actually, we think either of these are appropriate ways of solving this problem. And really, it's down to the administrators working out actually which one of these works best with our technology and our ways of working. But if that's being presented to a trustee, the trustee should have some comfort that us as a working group think either of those approaches are valid approaches. We then started getting into question 2, which is when we're looking at paying arrears and interest to members, what are the operational things that come in there? What are the tax considerations? What are the different options about what you might want to communicate to members? I mean, are there rights or wrongs about what we should put into those letters? And again, what you'll see when you see our answer is that we think there's a balance of different things here. For example, when you're looking at arrears that have been paid to people and whether you need to break them down by each tax year because some members might be able to claim that back, or whether actually you can lump that in the letter, make the letter smaller and simpler, and make sure you can just answer that question for the members who come back and ask you. We landed in a place where, again, we think it's reasonable to do various steps, but what we're going to call out in our guidance are the things that administrators need to think about on that decision. So, for example, if you decide that we're going to have a simpler letter and we're not going to pay, including that an arrears breakdown, then make sure as an administrator you thought through how do you deal with that query when it comes in from a member. Is that data readily available? Where do you get it from? Make sure you thought all those downstream operational impacts out, and that's where the group can help because we can specify what those bits are so you can bring that into the design of what you're doing. And the question we're looking at the moment is about death benefits. Clearly, this is going to be a little bit more complicated, particularly in the dual record world going forward. And we're looking to put down some guidance on what are the key things that administrators need to consider when designing their operational processes to cope with death benefits. Now, one of the key things for us on the question and answers is that we're here to help, we're here to support, but we do need your help too. And what this drawing is trying to show is how we aim to work the group going forward. So we need questions. We need to know what are the administration or operational things that people are worried about, people have got concerns about. Now, because we've got a wide-ranging group with people from different organisations in it, we'll be able to generate some of those questions ourselves. But actually, we need your help. We need you guys out there to let us know about the things that are worrying you. We're going to have on the PASA website a place where you can go to put those questions to make sure that you can let us know about what they are. And if you can't find that, or that's not available right now, then you can contact me. You can come to me and I can look at fielding that question for you. And then within the working group, we'll be able to consider that, think about what we're doing, and we'll come back to our core principles, the ones that I talked about earlier, the key points that drive what we're thinking about. But we're also going to look at all the other PASA guidance that's out there. We don't want to rewrite the excellent material that's already out there. I always go on to people to say, look, if you are new to GMP, go and read the methodology guide that PASA written. It's a brilliant introduction into the topic. So what we're going to be able to do is make sure we refer back to those things and point people in the direction of those things so we're not rewriting all the good material that's out there. So we'll bring all that together and that will feed into our ever-growing list of question and answers that will be available on the website. So where does that leave us at the end? Well, as I mentioned just then, we need your help. We want to know what are the practical issues that you're considering and what are the things that you're worrying about when thinking about how do you run a pension scheme after a GMPE solution has delivered and solved the historical problems. What is life after GMP for you? So please do tell us those questions and concerns, and we can give you some expert documented guidance and opinion to help you get to the bottom of those things. And we've got our own page on the PASA website, so you can go there and find out a bit more about us. And like I said at the beginning, it's not a closed shop. If this sounds like the kind of thing you'd like to get involved in, then please do let us know. Well, that's all for me on administration. So at this point, I'm going to hand over now to Felicity and Claire to talk a little bit about anti-franking.
Thank you, Stephen. My name is Felicity Boyce and I'm a consultant at Aon, and I'm joined today by Claire van Rees, who is a partner at Sackers, here to provide a legal perspective. Now, why are we here today? Well, the original methodology guidance included a page on anti-franking, but we've had requests from people saying, we want more information, we want more detail. So we've put together a small group that has produced today's guidance, which acts as a supplement to the original methodology guidance. But for those of you who haven't spent the last couple of years going, I'd like more information on anti-franking, Claire's going to do a basic introduction. What is anti-franking?
Thanks, Felicity. So I'd say the legislation relating to anti-franking isn't very long, but pensions lawyers like me tend to view it as one of the most complicated bits of pensions legislation, which is really saying something given how technical and complicated a lot of pensions legislation is. In very big picture terms, the purpose of the anti-franking requirements is to make sure that revaluation or increases on the GMP don't eat into and erode the pension in excess of GMP. And the reason that special rules are needed for this is because while GMP is in many respects a separate part of the pension benefit, it is, as the name suggests, still a minimum benefit. So the anti-franking requirements impose an underpin test when the GMP comes into payment, and if the benefit's less than the anti-franking minimum, then it's uplifted. A point to note is that the strict anti-franking test only applies directly in certain circumstances, but when it doesn't apply directly, it does still generally tend to get dragged in indirectly by the need to meet the requirements of preservation legislation. I'm going to very briefly talk through some of the components of that anti-franking minimum test, which are set out on this slide. Very broadly, these are first the relevant sum, which is the starting pension at cessation date. Now, cessation date is the earliest of the date of a member leaving pensionable service, their GMP age or possibly state pension age. There's some debate about that, which that is in some circumstances. Or if the scheme ceased to contract out before April 2016, then the date that the cessation of contracting out happened if it's before those two events. On top of the relevant sum, you add GMP revaluation and increases since cessation date up to the date of the anti-franking minimum test at the date GMP comes into payment. And the next two elements don't necessarily apply to all members. The later earnings addition is very broadly trying to pick up salary increases that might get factored into your pension after your cessation date. So that won't apply to all members if they left pensionable service at their cessation date, for example. Then you also got the appropriate addition, which is again only applicable in certain circumstances. That picks up additional accrual after cessation date and late retirement factors on excess over GMP. The legislation also describes commutation, surrender and things like that as being disregarded for the purposes of the anti-franking test, but it can be easier to consider that as an explicit reduction to the minimum. Then at the end of this slide, we've got deferred revaluations, which are not strictly speaking part of the anti-franking minimum, but they are, you do have to add those on top as a result of other legislation. So it's often included in the anti-franking test for simplicity. Some schemes are not subject to the revaluation requirements. And so for those schemes, anti-franking still applies, but the minimum wouldn't include this element. A point to flag is that the later earnings addition often gets overlooked, but it can be really quite important in the context of certain members and GMP equalisation. So Felicity is going to talk a bit more about that later. Another point to flag is just, I mentioned earlier that there can be a bit of confusion about cessation date and whether you're looking at GMP age or state pension age. And that's just because the legislation is a bit unclear. Different schemes, in certain circumstances, different schemes take different approaches. For much of the period you're looking at, GMP age and state pension age would be the same anyway. So moving on to the next slide. What does the guidance cover? So you have this very technical bit of pensions legislation relating to GMPs, which ties into GMP equalisation. What is the PASA guidance actually looking to do? So it's trying to explain why anti-franking matters for GMP equalisation, who it matters for, and set out some possible techniques for applying what is a whole of service test in the context of GMP equalisation, which is just looking at a slice of benefits. It also includes some examples. And it's aiming to provide a pragmatic way through anti-franking in the context of GMP equalisation. What it's not looking to do is be a manual explaining everything to do with anti-franking. That's not that. It's focusing on the interaction with GMP equalisation. And it's also not looking to give definitive answers to areas of legislative uncertainty. So there's a lot of uncertainty in anti-franking and how it applies around matters such as how you apply it where you have multiple normal pension ages, questions over whether you can frank post-97 pension increases, and the point that I've mentioned about are you looking at GMP age or SPA for cessation date in some circumstances. So the guidance isn't looking to take a view on these or existing areas of difficulty, because we're not looking to unsettle views that schemes will already have taken off the back of having taken legal advice and other advice on how to do things. So if you think you have wider difficulties with how your scheme's been applying anti-franking, then guidance is not going to give you the answers, and you should be speaking to your normal scheme advisors. We're also not suggesting that the possible techniques in this guidance are the only ones. The aim is to be helpful by suggesting what's likely to work best for most and some alternatives, but there will be other methods out there that might make sense depending on the scheme's circumstances. So I'm now going to hand over to Felicity to talk a little bit more detail about the guidance.
Thank you, Claire. So why is anti-franking important enough to have its own supplementary guidance? Well, part of that is just because anti-franking is quite complicated, but it's also because anti-franking can have a significant impact on GMP equalisation. And the key reason for that is that anti-franking is very sex-specific. The anti-franking depends a lot on when your GMP age is. So for people who are retiring under GMP age, any step-ups will happen at GMP age. For people who are continuing in service past GMP age, then the later earnings addition, appropriate addition will be accruing from GMP age. But GMP age is different for men and women. So 65 for men, 60 for women. So having a large impact. This will vary a lot by scheme. However, I have seen some schemes, and in fact I've implemented equalisation on one recently, where for pensioners, over half of the equalisation uplift was due to the later earnings addition. Now, it was partly because otherwise the benefits weren't that different, but it's still a significant impact. So who does anti-franking matter for? Well, this can be divided into two broad categories. There are schemes where anti-franking is going to have a particular impact because of their benefit design, and then there are members who it will have a particular impact for because of their specific characteristics. And schemes where the benefit design impacts a lot tend to be those where the normal pension age is less than 65, and either they don't give any pension increases on excess in payment, or they don't give full revaluations on GMP for members who are retiring prior to GMP age. So either they get no revaluations whatsoever because the legislation doesn't actually require them before you reach GMP age, or they give revaluations at a lower rate. For members who will typically have significant GMP anti-franking uplifts are either those with quite high GMP proportions, or those with pure GMP pensions, so GMP only members, anti-franking doesn't actually apply to, but those where it's 80–90%, you've got a good chance of anti-franking uplifts, and those members who continue in service past age 60, where the female will start accruing a later earnings addition. Now, anti-franking is complicated enough in its own right anyway, but applying it to equalisation makes things worse. And this is because anti-franking was designed as a whole of service test, and the legislation never gave any consideration for what would happen if you tried to apply it to only part of your benefit. But equalisation, you only have to do it on post-90 benefits. So how do you deal with this? Well, the guidance proposes 3 potential approaches, which on the next slide, please, Susan. So 3 potential approaches. These are not the only possible approaches. I'm aware of at least a couple of others that I've heard proposed, but we've focused on these 3. First is the ring fence approach. Now, this is the simplest of the approaches. Simplest is a relative term here, but what the ring fence approach involves is you apply the standard anti-franking legislation to the 90 to 97 benefits in isolation. And this approach we'd expect to be used by a fair number of schemes. It's the simplest, it requires the least data, it can produce some funny results in some circumstances, but so can every other approach that we've looked at. The second approach is what we've called the DWP 2012 approach, and this has been extrapolated from some examples in the DWP's 2012 consultation paper on equalisation. And this is what we've called a whole of service mixed sex approach. What you do is you take the original member and you apply the anti-franking rules to the member's entire benefit. Then you take a second pension stream, which is constructed of the original member's benefits prior to 1990 and the opposite sex's benefits after 1990, and you apply the anti-franking to that. And exactly how you do that is gone into in a little bit more detail in the paper. The third approach is the apportionment approach. And again, this is a whole of service approach, but this time you do it on just a pure sex basis. So you compare the member's original pension and work out what the anti-franking uplift is for that. You compare the opposite sex's pension for the whole pension and work out what the anti-franking uplifts would be for those. And then you ratio it down to just a 90 to 97 element. So ring fencing requires only 90 to 97 benefits. The DWP requires pre-90 for the member and then post-90 for member and opposite sex. The apportionment requires pre-90 as well as post-90 for both the true and opposite sex. So there are differences there in the amount of data you need, and there is also an additional layer of calculations on some of the later ones. So that's why we end up with the ring fence as being relatively simple, and we'd expect a lot of schemes to be using it as a starting point. But the other methods are valid too, and there are other methods beyond this which will also be valid. Next slide, please, Susan. So what are the messages we want to you to take away? Well, the first of these is anti-franking matters. For some schemes, it will matter more than others, but it can be the cause of significant uplifts. And it will potentially matter for all schemes subject to GMPE equalisation. It's quite challenging to think of a scheme benefit structure where you can say with certainty no member in this scheme will ever be subject to anti-franking, assuming that GMPE equalisation applies to them, so they do have post-90 GMP. Next, don't ignore the later earnings addition. Now, Claire touched on this briefly, and I'm going to use later earnings addition here slightly loosely as being the overall impact of anti-franking for members who continue in service past state or past cessation date. So for these members, you can end up with uplifts to benefits of, say, 25% of GMP at their date of exit, sometimes as much as 40% of their GMP at GMP age. And when that's being applied only to the female, you're suddenly going from a situation in which both members had the same pension at date of retirement to the female has a significantly higher pension at date of retirement than the male, so the male requires a corresponding anti-franking uplift. And the later earnings addition is something that schemes have often not paid huge amounts of attention to in the past. Often members would retire once they reach state pension age, so you wouldn't have that many members for whom it was relevant for. However, once you start doing anti-franking, or what you start doing equalisation, you have a situation where all of those male members who retired at 65, so the later earnings addition wasn't relevant to them, suddenly you care about what the opposite sex comparator would do. And the opposite sex comparator has been accruing a later earnings addition between 60 and 65 and is suddenly a fair bit higher than the member on their retirement at 65. Finally, there isn't a perfect approach to dealing with anti-franking in equalisation, but there are ways forwards that we can use. We've given you some potential ones, and the guidance goes into more detail and gives you some examples. So that's everything from me, thank you, and I will hand over to Chris to take questions.
Thanks, Felicity. We've got a few that have come through, which is good. As you'd expect from Stephen's introduction, he wasn't looking for to answer any particular questions today, so all the ones that have come in so far have been on the anti-franking section. So the first one, you said it's complicated and not always well understood, anti-franking as a concept. Do schemes need to revisit how anti-franking has been done historically?
So schemes will need to understand how their anti-franking has been done historically, because they will need to be able to replicate it for their equalisation calculations. Now, there are a lot of ways in which anti-franking can be done. Some of the ways are more generous than is required. Some of them there are areas of legal uncertainty, but you can be happy that what you've done is legally justifiable. But maybe some cases where schemes have just not met the requirements, and in those cases, schemes are going to have a problem, which they'll need to look at.
Okay. And you mentioned that where you've got a male who retired at 65, later earnings addition doesn't apply until you start looking at equalisation, where their opposite sex comparator, it would have kicked in from age 60. Does the guidance cover anything around finding missing salary information for that period, or is that come under the remit of one of the other GMPE subgroups?
So the guidance doesn't cover that, no, and we understand that often getting hold of the salary data can be difficult. If you've had members who are accruing benefits in the 90s, then you might have records, but they might have been on a paper file that got destroyed 20 years ago. And in those situations, we'd say still don't ignore the later earnings addition, but it is likely to be reasonable to make an assumption about what the salary increases will be. And what that assumption is going to be dependent on what you know of the scheme's history. So in a lot of cases, it might be reasonable to say, well, the member was close to retirement, they probably wouldn't be getting much in the way of inflationary increase, promotional increases. We'll just assume that their salary increased in line with inflation. There are some schemes I know where managers with perhaps less understanding of how pensions work than would be ideal thought, well, I know so-and-so has been a good employee, and to help him out, I'm going to give him a big boost to his salary right before he retires. That will boost his pension, but we won't have to actually pay him this extra salary, so it won't cost us anything. So in those situations, if you know you've had a company where people have tended to do that, then you might want to be thinking about a higher salary assumption.
Okay. If you've got a scheme which gives full inflationary increases on total benefit, does that mean that anti-franking ceases to be an issue?
So that's the situation that Claire alluded to earlier, where some schemes are not required to give the excess statutory deferred revaluations in addition to the anti-franking minimum. So for those members, the anti-franking minimum will be in some circumstances lower, which makes it less of an issue. However, that doesn't mean it's never going to be an issue. In particular, that situation won't impact at all on what the later earnings addition is at all. There may also be some situations in which the member's GMP is still high enough to bite, even in step-up cases.
Okay. Where you were talking about the ring fence method being one that would be adopted as opposed to the DWP 2012 method, you mentioned that you needed a split for pre and post 90 for the DWP 2012 method. Is that a split of benefits for both GMP and excess, or just for GMP?
So it certainly needs to be a split for GMP. My initial inclination is to say for excess as well, but I haven't thought about that in a lot of detail. One thing that you will find in practice is that I want to say for a fair amount of time the absolute amount of excess doesn't matter that much, but the trouble is most of the times it does matter are those times when you start having anti-franking uplift, so which does not make this the best webinar to say that. So you need to be able to say what the difference is between the excess for the male and female, but that you can largely do based just on the change in GMP. Yeah, I'm not going to give a definite answer on that, I'm afraid, Chris. I need to go away and think about that one a bit more.
Okay, so to the person who asked that question, we could maybe respond in some more detail afterwards. That's fine, thank you. Can you elaborate a bit more, either Claire or Felicity, on the GMP only members and the anti-franking point in relation to them, please?
So, do you want to take this, Claire, or shall I?
I suppose the point is that if somebody's a GMPE only member, there's no excess, so you're not doing any anti-franking, but not entirely sure what the question's getting at, Felicity.
So my understanding of the legislation is that if you have no excess at cessation date, then anti-franking doesn't apply directly or indeed at all in practice. Because the point of the anti-franking legislation, as Claire says, is that you're not allowed to eat into the excess. Now, anti-franking will still apply if you have excess at the cessation date, but you've run out a bit later because you've commuted it away, for example. Chris, are you there? You've gone.
I think Chris and Felicity have got connection problems. There's Felicity back and Chris.
Yeah. Sorry about that. Chris, I can't hear you. Are you muted?
Yes, I was. Sorry, obviously had a connection issue there and I dropped off. So yeah, apologies for that. We do have some more questions if you're happy to carry on. We've got a bit of time still to go. Can you change your approach to anti-franking from a more generous one to a legal minimum approach when implementing GMPE?
I think that's a tricky question and one that's not something that we'd cover in the guidance, and I would direct people to their own legal advisors in the context of their scheme, because I think it will depend very much on the specific scheme circumstances potentially.
Okay, thank you. What guidance is there where you don't know what the scheme did for anti-franking calculations 25 years ago, for example, under a prior administrator or a legacy section?
I mean, my view on that is that it, and Felicity's probably got views, but my view is it kind of comes under the general bucket of what do you do generally about GMP equalisation when you have gaps and don't know what what's happened in the past or what's been done. And I think it will depend on the circumstances and what's doable and what's proportionate, in much the same way as it does in other missing information in the context of GMP equalisation. But Felicity might have some more practical thoughts on that.
No, so I'd agree broadly with Claire. So there's a starting point, I suppose, of do you think anti-franking's been done correctly? Usually in that situation, you won't have reason to think anti-franking hasn't been done correctly. At which point I'd probably start by assuming that things have been done in line with statutory minimum, but often there will be some clues on that. So for example, what are you doing now? If you know you're doing such and such now, then it's probably reasonable to assume that practice has continued in the past.
Okay.
Yes, ultimately one for your legal advisors at the time.
Okay, we've had a number of similar questions along that kind of theme, so we'll move on to a different one. Is it possible to offset the later earnings addition against post-97 or pre-1978 benefits?
So the problem here is that you're not actually getting much in the way of increases. Now, things it is potentially possible to offset the later earnings addition against include Barber LRFs if you give them in active service, which a lot of schemes won't do. But in terms of can we offset against post-97 pension increases, well, you haven't retired, so you're not getting any post-97 pension increases to offset.
Okay. There aren't many more questions coming through now. I'll just give people a couple more opportunities just to send them in if they've got any. Stephen, if I could turn to you for a minute on admin. You mentioned system upgrades a couple of times in your presentation, including in relation to readiness for administering dual records. Has your group got a view on how ready the industry is in general? And is it likely schemes will be able to switch in the short term, or might it take a bit longer?
Yeah, I think it's very different for different sort of administrators, different software providers. So I think it's a different. It depends who they are, and it's really important that trustees engage with their actual administrators to find the answer to that question. In general, certainly from the group, from the people in our group, all of those organisations are really engaged in doing it. So they're either live already or are getting close and have done a lot of the thinking already to get that kind of stuff underway. I think in reality, we've seen that GMPE projects are taking longer than maybe people thought they would from the outset for reasons including things like anti-franking, which makes them much more complicated as people get into the weeds of them. So we've only seen relatively small numbers of schemes to go live with dual records yet, so it hasn't been a significant problem for the industry yet. But clearly more and more of them will be going live over the coming months and years. So I think the industry is getting there, but it's really important you check with your individual administrator to see where they are and what their timeline is.
Okay, thank you. Well, there's no more questions coming at the moment, so I think that probably means we can wrap up a little bit early. I think it's been a really useful session. Thank you to Stephen, Felicity and Claire for that, and thank you to the audience members for sending in the questions. There are some more webinars going on over the next couple of days of this week. The one tomorrow is about implementation experience, as easy as BCD. So that sounds like it will be interesting. But other than that, thank you very much to everybody for helping to put this on today, and see you shortly. Thank you.
Thank you.